Well, kindly look at it from this point of view. 356 itself is a temporary provision. What's the purpose of 366? To restore democracy. Is the intention behind the 356 position, which is a temporary provision, to decimate democracy?
No, it's simple. Let's keep 356 aside for the time being, because we are now interpreting 370. We are interpreting clause 3.
Yeah. I'm just
70.
Yeah, I appreciate
we can't bring.
No. I'm only saying these are issues that will arise.
If one looks at it carefully,
yeah.
subclause B2 says such are the matters in the said list with the concurrence of the government of the state, the president may by order specify. So all other matters which are not included in clause 1 can be now the parliament of the country can legislate with the concurrence of the government of the state.
Correct.
Now, what is meant by the concurrence of the government of the state is specified in clause 2.
Yes.
As long as there is no legislative assembly.
Correct.
In that case, it's the Constituent Assembly which will have the power.
Yes.
And after the state assembly has been constituted, then it will be placed before the state assembly.
Correct.
That's the purport of clause 2.
Absolutely right. So that's also worked itself out.
One.
Yes.
But once the state assembly has been constituted,
right.
in terms of the constitution of the state, then it is governed by the proviso first and the second proviso to clause 1.
Yes.
Which says, provided that no such order which relates to matters specified so and so in consultation with the government of the state, concurrence is not required because it's already included in the order of accession. The second proviso applies when it is not included in the order of succession and says, provided further that no such order which relates to matters referred to in the last provision shall be except with the concurrence of the government.
Correct.
So all that is required is concurrence of the government.
Right.
But to say that the proviso to clause 3 will operate even after
it says this article shall cease to operate, not just any laws, that this article shall cease to operate. There's a difference, Malak. Actually, proviso 1 and proviso 2 have worked themselves out. Because now you have a constitution?
Yes, it's not worked itself out. It will continue to apply as long as there is concurrence of the state government.
That's right. And in between, the constitution in 1957 is framed, so that there was no CO after that, except for the ones. There were a couple of COs, but ultimately it's in three. It's that's different. It says, notwithstanding anything in foregoing provision of this article. This article.
We are interpreting 370. Let's look at it. Let's look at clause B, C, and D for a moment.
Yeah.
B, C, and D cover two types of situations.
That's
one. It covers entries of the union list and the concurrent list.
Yes.
And it covers substantive provisions of the Constitution also.
Yeah.
Now, clause B refers to the power of Parliament to make laws for the state.
Yes.
And it restricts it in two ways.
Yeah.
First, those matters which are governed by the instrument of accession, those entries in the union list and in the concurrent list, which are referable to the instrument of accession insofar as it reserves powers to Parliament.
Right.
Those have to be specified by the Government of India, by the President.
Absolutely.
In consultation with the state.
Absolutely.
So B1 refers to those matters in the union list and the concurrent list.
Right. Right.
B2 refers to such other matters in the said lists in which concurrence of the government of the state is concerned. Right? So the entirety of B is confined to matters in the union list and the concurrent list.
Correct.
Now we come to clause C.
Yes.
Clause C refers to a substantive article of the Constitution, Article 1.
Yes.
Right? Now we come to clause D.
And 370, not just Article 1.
Right. And of this article, you're right.
And this article.
And now clause D. Clause D refers to such of the other provisions of this constitution.
Right.
They shall apply in relation to that state subject to such exceptions and modifications as the President may by order specify.
Correct.
So clause D now is beyond the ambit of clause A. Clause A refers only to the entries of the union list and the concurrent list, right? Clause D refers to the other provisions of the constitution, apart from the union and the concurrent list.
1 and 370. This is the problem.
Right. Now look at the proviso to clause D.
Yes.
The proviso says that no such order which relates to the matters specified in the instrument of accession of the state referred to in paragraph 1 of subclause B.
Correct.
Shall be issued except in consultation with the government of the state.
That's right.
In other words, the first proviso
Yes.
refers to the entries of the union list and the concurrent list.
Yes.
Right?
Right.
The second proviso provided further that no such order.
Yeah.
Now, which is such order? It refers to the order which is referred to in the first proviso.
That's
Therefore, the use of the word such order, which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of that government.
Correct.
In other words, the whole area of concurrence, consultation and consent is confined to the entries of the union list and the concurrent list. Because that's very clear from the whole scheme. B1, matters in the union list and the concurrent list. B2, such other matters in the union and the concurrent list.
Yes.
Then go to clause D.
Yes.
Clause D refers to the provisions of the constitution,
Provisions of this constitution.
of this constitution.
Yes.
Right?
Yes.
Now,
Subject to it will be
the presidential power, to the power of parliament or such of the provisions of this constitution shall apply in relation to the state subject to such exceptions and modifications as the president may by order specify.
Yeah.
In other words, the president is given an untrammeled power to specify which are the provisions of the constitution which shall apply to the state of Jammu and Kashmir. That is conditioned by the first proviso and the second proviso.
Right.
But the first proviso and the second proviso don't relate to the substantive provisions of the constitution at all. They only refer to the matters governed in the union list and the concurrent list.
Only the first proviso, not
One second.
Orders, Mother.
Right. You're right.
Yes.
Deals with the presidential order.
First proviso mentions the list, but not the second proviso.
D recognizes as inhering in the president the power to decide which of the substantive provisions of the constitution shall apply to Jammu and Kashmir. Now that power of the president is conditioned by the first and the second proviso.
Yes.
But the first and second proviso to clause D
only provided further that no such order shall relate.
So no such order means the order referred to in the first proviso. And the first proviso only refers to clause 1 of subclause D.
Not these only orders. These orders.
I understand that, yes. No, 1 second. No, you're not getting the point. The point is this, that D refers to an order which may be passed by the president making applicable provisions of the constitution to the state of Jammu and Kashmir with adaptations or modifications. Now the question, including the list, now what the first proviso says is that no such order which relates to matters specified in the instrument of accession specified in paragraph 1 of clause B shall be issued except with consultation.
The instrument of accession, Mother.
But that pertains only to the entries in the union list and the concurrent list.
Yes.
Absolutely.
Yes,
the face of it.
That's
the second proviso, Mother.
Now the second proviso. Now the second proviso says, provided
other than
that no such order which relates to matters other than those referred to in the last preceding proviso.
Concurrence.
Therefore,
which includes D, Mother.
No. It refers only, it cannot. I'll tell you why. Provided further that no such order means which order? The order referred to in the first proviso. And the order
mentions order, Mother.
Sorry?
He also mentions order.
provisos use the word such order.
Such order.
Refers to the order in D. Just 1 minute.
But it is not. D also says the same thing. My order specifies the power of parliament. Now here, Mother, it relates to the power of parliament. to make laws. Just kindly note that.
That's the ordinary lawmaking power.
Yes, the ordinary lawmaking power for the state shall be limited. Now that's important. Even the lawmaking power is limited to those matters in the union list and the concurrent list. Your lordships will see state list is out because residuary power is in the state, which in consultation with the government of the state are declared by the president to correspond to matters specified in the instrument of accession governing the accession of the state to the Dominion of India as the matters with respect to which the Dominion legislature may make laws in that state. So that's that list, Malaj.
We saw the list in the morning.
The list in the morning. So it is only those that Parliament may make laws, but that also with consultation. And consultation is mentioned here itself. Doesn't have to be repeated in the proviso, it's mentioned here itself. That also has to be consultation. And just let's clarify the architecture. So that's with consultation. Now you come to B. Such other matters, that is again power of Parliament to make laws. Such other matters in the said list. So apart from the list that are in the instrument of accession, such other matters in the said list.
This list refers to union and concurrent list.
Yes. Only list 1 and 3.
1 and 3.
Yeah. As with the concurrence of the government. So now, Malaj, that law has to be also with concurrence of the government. So we are dealing only with laws here, lawmaking power. That's the first, Malaj, limb of the argument.
That's the restriction on the lawmaking power.
That's the lawmaking power. Concurrence is mentioned here in respect of other matters, Malaj. No proviso is required. Here, no proviso is required. Now, let's leave the explanation for the moment. The provisions of Article 1 and this article shall apply. C. The provisions of Article 1 and of this article shall apply in relation to that state. So, this is Article 1 and this Art 370. This becomes relevant for D, ultimately. Now come to D. D starts with the word. Now, D doesn't deal with laws. It deals with proclamation and orders of the president. Provisions, such of the other provisions of this. I pause here, Madhavs. Others excluding 1 and 370. So D is, C says the provisions of Article 1 and of this article shall apply in relation to that state. And D says such of the other provisions, that is excluding 1 and 370, shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify.